Good afternoon, everyone. We UCC are so happy to have you, everyone, here today. Let me open today's meeting here. And software is widely used in many kinds of industries. Also, China is offering better and better opportunities for software development. However, companies still have to meet increasingly complicated and changing regulatory and compliance environment for IP and data protection in China. Meanwhile, you could also find some information from our EU CCC's position paper, which has been published in this September. Today, we are really glad to invite Ms. Lisa Lu of China IP SME Helpdesk, Mr. Charles Feng of Tahota law firm, and Mr. Phillip Neumann of AppinChina to share their special view and practice on software IP protection, data private and IP protection landscape, and also compliance and other practice consideration for companies. Now let's us together look forward to their professional sharing. Thank you so much.
Wonderful. So before we get started with the presentations, maybe just a couple of words about the organizations that are co-organizing this meeting. Lisa will talk a bit more about the IP SME Helpdesk. I will mention the EU SME Centre. And the EU SME Centre is an EU-funded project that was founded in 2010. And its goal is to support European SMEs to really better understand the Chinese market if they decide to enter it via exports or investment. The EU SME Centre, as you can see, is supported by 4 main consortium partners, one of which is the European Chamber, and 2 associated partners. And this meeting today is being organized in the context of our advocacy platform. Here it is, which aims to bring together European SMEs and institutional stakeholders to discuss what the key market trends, policy trends, and issues for these small companies are when it comes to operating in the Chinese market. And of course, IP is a key consideration for companies, and that's why we work quite closely with both the European Chamber and the IP SME Helpdesk. Okay, gonna stop here, and we can go to Lisa.
Thank you, Esther. Hello, everyone. Good morning, good afternoon. And I'm from China IP SME Helpdesk. So this is a project funded by European Commission. We assist the SME, small and medium-sized enterprises when they internationalize to China, and we provide a free initial advice to SMEs. For now, we cover 4 jurisdictions, including mainland China, Hong Kong, Macau, and Taiwan. And so far, we already assist more than 100,000 SMEs. And so how do we work? How do we support SMEs? When they have inquiries, they can write to us to our helpline, and they expect to receive the replies, our replies within 3 working days. And besides the helpline, we also offered one-on-one consultation and training and workshop like now here. And also the SMEs can download the guides, the publications from our website. From our website, there are a lot of sources such as case studies and the IP tool. Besides China IP SME Helpdesk. We also have Latin America, Africa, India, Southeast Asia helpdesk. So when SMEs want to expand their market to any of these countries, and they can always write to us. Just a few words about me. Before joining IP SME Helpdesk, I work in 2 different law firms in China, and where I obtained Chinese lawyer's license. And I hold a double master degree in China University of Political Science Law and University of Hamburg. And let's dive into our presentation today. Firstly, I'm going to introduce why IP is important for software. And following that, we will see how to protect software in China, which type of IP you can consider. And later on, we will discuss what type of remedies when you encounter software infringement in China. So why IP is important for software? First, like the other products or in this industry, if you register the IP, you can enjoy the exclusive right to explore your software in China. So if anyone else used your software without your consent, you can take action against that. And also software IP attracts partners and investors. And according to the statistics in 2023, there are already more than 2 million software copyright registered in China. That has been increased by 35% year on year. So of course, when China people start to value IP more. So if you have more IP over your products, such as software, you will get more advantage when you negotiating with your investors. And software IP generates additional revenue streams. And our third speaker will introduce about how to publish software in China. And publishing software in the different platforms, it's one of the channels that you can generate the revenues in China. And also, if you have IP, it will prevent competitors from using your software ideas. And at the same time, if you encounter any infringement, the IP will allow you to take actions against them. However, if you do not have the IP in China, that will be impossible or very, very unlikely to take any actions. And this is a very basic 3 principles when you try to understand the IP landscape in China. First is registration. That applies more widely in trademark and patents. That means without registration, your IP will not be protected in China. And if you only apply for the trademark or patent, it's not sufficient. You have to wait until your right is granted. And the second principle is IP is territory right. That means if you have European IP, that doesn't mean you have the protection in China. You still need to go through extra registration procedure to obtain the protection in China. The last principle is first to file. That means whoever is the first to file the IP and get it registered in China, they can claim they are the IP owner in China. Therefore, we always recommend the rights holder to register rights in China as soon as possible before anyone else to do that. And if you look at the IP types in China, you will find they are very similar with those types in EU. There are still some difference. For example, there are 3 types of patent in China, including industrial design. And also there is a copyright registration procedure in a lot of countries in Europe. There is no registration procedure. However, if you look into the details of each type of IP, it's still very similar with European Union system. So for invention patent, it protects the new technical solution or process. It requires the invention to be absolutely new. That means it should not be put into the markets, not only in China, but anywhere else around the world. That applies to all types of patent, including utility models and design patent. And later on, I will explain in details that software can be patented in China. That's very different from Europe. And for utility models, it protects the functional part of the products, like functional design. And this is not that relevant with software. The third one is design pattern. For example, if your software or your app has the graphical user interface, and you can consider to use design pattern system to protect it. And for trademarks, everyone knows about trademark. It protects the brand name, brand logo. And because you're coming to the China market, so having a Chinese brand name will be very, very helpful for your branding. And for copyright, it protects the software, logo, brochure, the videos you create. And this is the copyright registration procedure is voluntary procedure. That means you do not need to register your rights. The rights will be automatically get protected here in China. However, we still recommend you to do that because it's related to the software publishing and also software enforcement. And the last one is trade secrets. You can protect some of your business information, technical information as trade secrets. So to protect software, the most important and the most common IP type you need to consider is copyright. And as I mentioned, this is automatically protected once you create it in the countries in Berne Convention, including all member states of the European Union, also China. And if you want to enforce your rights, you still require registration certificate. That's why you need to register your copyrights. And if you register your copyrights in China, the Chinese authority will not charge anything for that. But if you hire IP experts or agency to do that for you, you need to pay for that, naturally. And the protection term of copyright lasts for 50 years. And after you get the registration certificate, the information on the certificate will be regarded as correct and the correct information, unless there is contrary evidence to show those information is wrong. However, software only protect the source code. Software copyright only protect the source code. For the core idea, it does not protect the it does not provide the protection. After the registration of your copyright, you still need to implement robust technical protection measures. There are a lot. Talk with your IP department and IP experts, including encryption and digital rights management, and also secure your licensing system. That's how you protect your software from being stolen by someone else. So we already mentioned different times about register copyrights, how to register that. A very simple illusion of the procedure is first you open the user account, then you can do all the application online with the required documents and information. Usually they will require you to submit the first 30 pages of your source code and the last 30 pages, not the entire source code. That will in some way prevent your technical information from being leakage. And after waiting for around 30 days, the certificate will be issued to you. And the Chinese authority will not charge anything from copyright registration. And different from Europe, software can be patented in China. How to make sure your software is patentable in China? You have to see the criteria applies to all the invention patent. So for a software to be patentable, it should solve a technical problem and use technical means and achieve a technical results. And the latest guideline lists 4 of the common software that can be patented in China. And these guidelines only released earlier this year. So if your software tick any of these 4 criteria, one of them, you can talk with the patent attorney in China and to see if your software can be patented. First is the computer program for industrial process. And the second is the software which can be used to improve the internal performance of computers, and the software which control, measure, or test process, and the software which is to use to process external data. And the last one is more common, based on based on some SMEs who talk with me. So if your software actually process the external data and using the AI and achieve these technical results, then we will recommend you to talk with patent attorney and to see if you can patent in China. And to patent in China, generally there are two routes. However, because patent software is not an option in Europe, so if you want to patent your software, then you should only consider national routes in China. But if your software has the graphical user interface and you want to patent it as industrial design, then you can consider the national route and the international route. The difference between that is the protection, the protection. So for the national routes, because the application only submits with the Chinese authorities, so the protection only applicable in China. But the international one allow you to file only one application, and you can take different jurisdiction you want to get protected. And eventually you can, after one application, you can get the protection in different countries like Europe, EU, US, China, Japan, South Korea, depending which country you choose and depending the national IP office final decision. And a very important type of IP you should consider to use to protect your software is trade secrets. So I list some of the measures you should consider when you take measures when you protect those published information. But this is not an exclusive list. You should add more measures you can think of that will be more comprehensive for you to protect your software. First, including the categorizing your business information as confidential. And then you should control the accessibility of those important documents and make sure only those employees in key position and they need to know those information can access to those information. And as I mentioned, you should implementing robust IT security measures. And also you have to make sure your employees understand your expectation on how to protect those trade secrets. Because in China, 82% of the trade secrets leakage are from employees. That's a very high amount, high portion. And therefore control your, make sure your employees understand the expectation and comply with those policies is very important. And regularly review the external communication and sign the NDA with your partners. And the other types of IP you should not miss either, such as trademark and industrial design. For trademark, if you do not have trademark in China yet, you should seriously consider. That's very important for your branding. And before you register any trademark, you should do a search to see if there's any similar trademark already exist in the market, or if your trademark is registrable in China. And for the graphical user interface, if you have any, consider to register as industrial design. And if you already take all the protection measures, and unfortunately you still identify infringement, how should you handle this situation? There's a roadmap for your reference to better understanding the enforcement in China. But our second speaker, Charles, he will introduce some case studies he handled so you can understand it better about the infringement. So after you identify the infringement, the very beginning and very essential step is to collecting and preserving evidence. And in terms of the evidence, there are three types categorized of evidence you should take into consideration. First is the ownership. So if you already have patent, copyright, trademark, you should find out those certificates. And if you already use your IP, your software in China, collect those evidence to prove that you already use those your software in China, and whoever create a very similar software, there's evidence showing case that they know your software and they still copy that. And the third one is, of course, the infringement evidence that will require the advice from the lawyer, because you need to preserve those evidence. Preserving means maybe you need to have a public notary to notarize those evidence. Otherwise, it will be invalid in the litigation. Those evidence used in the litigation is quite different in China from Europe. So having an IP expert consultation is important. And after the evidence collection, what actions you can consider? If those softwares identified, those copycat softwares identified in e-commerce platform, you can consider noticing the platform and they will remove those infringing link. That procedure is very fast. It takes place within a week. So if you want to simply just remove those infringing link, you can consider this. But if you want to find out the whole infringing network, this notice and takedown actions may not be the best option. You can also consider sending a notification letter or have a lawyer to draft a cease and desist letter to the infringer, and hopefully they will comply with your demands in the letter and stop the infringement. And in China, you can also contact the administrative authorities, such as Administration for Market Regulation or the Public Security Bureau, and they have the right to do the investigation, or if they know where is the infringer. If there is a physical product, probably not the software itself, they can conduct a raid without alerting the infringer. And if it is your partner who infringe your software, and you can check if in the contract with your partner there's any provisions related to the mediation or to the arbitration. If so, you can use those measures to solve your problem. And the last resort is litigation. Is time consuming, and you expect to spend a lot of money on that. But litigation allows you to get the compensation with the infringer. And lastly, it's the takeaway messages. So firstly, you should order your IP assets and obtain IP registration. For trademark and patent, no registration means no protection in China. And even though copyright registration is voluntary, you should still consider that, because it's important for your software launching and also publishing and also copyright enforcement. And you should consult a patent attorney before patenting your software. Also take various measures to protect those confidential business information as trade secrets. Evidence collection and preservation is very important. And if you have any questions, you are welcome to contact us. I will give back the floor to Esther.
Wonderful. And our next presentation will be from Charles. In the meantime, feel free to when you start, if you want to introduce yourself.
So I'm Charles Feng. I'm a senior partner and director of the National Business Department at the Tahota Law Firm. Tahota Law Firm is one of the largest five largest Chinese law firms. We have more than 4,500 legal professionals across China in 25 offices. In addition to, we do have some overseas offices in Bangkok, Sydney, Sydney, Australia, Bangkok, Thailand, and in Paris, and also in Washington, D.C. So in the firm, we have more than 300 lawyers for English speaking mostly, and also in other languages in French, Japanese, Korean, German, and other language speaking lawyers. So we're able to provide the legal services, including IP, data, and also foreign investment, the dispute resolution in the whole area of law in China. Given our past, we have more than 170 persons who are formal officials from CINIPA, from various levels of Chinese courts, and also from many other Chinese authorities. We're able to help clients in different angle of our work. So I myself, I've introduced a little bit more in the latter part of the presentation today. And I used to work with, I graduated law in the US and China Foreign Affairs College, Affairs University. And also I work with Baker McKinsey and other Chinese large law firms before I joined in the current firm. So data protection, my speech will be about actually about 5 parts. The first 4 parts will be mostly on the introduction on unfair competition in China. The reason we pick this angle is because the speech we're requested today to deliver is about data protection and also the IP protection. So the data protection has been a very wide range of issues, which includes IP, because IP is definitely data can be a subject matter of intellectual property from the broader sense, and also from the other sense, there's a lot of other issues relevant to the unfair competition in China. And secondly, I will discuss in the last part of my speech today, I will discuss a little bit more about emerging IP rights for data. The reason I discuss this is because the data traditionally it has been treated either as a subject matter for copyright law of China, or it can be protected under unfair competition law of China as a competitive interest. However, in recent Chinese landscape, the legal, legislative, or enforcement landscape, there's some new takings or new considerations about the data. So the Chinese authorities are increasingly interested to put data as a new type of intellectual property right, which is a little bit different from the traditional IP, such as patents and copyright. They directly put data as a new type of IP, and in some Chinese judgment already being made on basis of such new type of IP on data. So I will, in the last part of my presentation today, I will introduce a little bit more about these new trends. So first of all, let me go through a few slides about the traditional protection of data. So the case I discussed is about McGraw-Hill. You probably know, by the way, the cases we discussed today are mostly handled by myself, but they are pretty representative about different types of unfair competition law of China. The first one, the McGraw-Hill. The McGraw-Hill probably know that is a famous publisher across globe in the US and also in the UK and other countries. So McGraw-Hill is a world famous publisher. It has published many educational material. If you go through English test, you know them very well. They publish a lot of TOEFL and other examinations, but they have a very special type of publication, which is about data. The data they have been publishing and been providing is about oil data. The oil data they publish was from their data collection from the different parts of the oil market across globe. So what we have had in this case would be the case happened about 10 years ago, 20 years ago. The plaintiff is called Plus. Plus is a subsidiary, 100% subsidiary of McGraw-Hill. The Plus is focusing on the collection and using and the commercialization of the data on oil price. So they have been collecting the oil price data across globe from the different part of the world, from different part of oil market of the world. And then they have been collecting, editing those data into a database and a commercial database as a publishment, and they publish them with their own platform and with their own as their own material. So that has been a big important data for the oil manufacturers across the globe to fix their price when they want to sell their oil in the oil markets across the globe. As a result, this data has been a very valuable material reference for the oil manufacturers across the globe. So therefore, this very important database has been with a huge business value, and that business has been targeted by a Chinese infringer called Jing Haixun about 20 years ago. Jing Kaixun has made this, and it has copied almost 90% of the data from the macro hill from the Plus, and introduced their own Jing Kaixun oil price services, and that has been provided to all of the oil manufacturers, which is definitely competing with macro hill and with Plus. And then this lawsuit has been filed by macro hill in 2006, alleging that the infringement has been made by the infringer, and the claim is on basis of two parts. One is a copyright. So the Plus regarded the database they owned has constitute the copyrightable subject matter with a copyright protectable subject matter as a database. And secondly, the claim will be unfair competition. So the other has been copying and distributing the data for their own benefits without authorization from the Plus. Therefore, they have given the unreasonable business advantages in the competition. So the lawsuit was initiated by the Plus with Beijing #1 Intermediate Court at that time. And then the case has been filed. Since this has been filed, and the two sides has been negotiated for a long time. As a result, the case was settled in about 2005, 2006. 2006, I think that the two sides has agreed to settle the case under the mediation of the court. And at the end of the day, the Jing Kaixun and his affiliate distributor Jing Kaixun agreed the following provisions. One is not publish information anymore without plaintiff's authorization. The second, they agreed to pay the damages to the Jing Kaixun at a certain amount, which is a very large amount, but not be disclosed due to commercial purpose. The third would be they agreed to refrain from any obtained through the production or through the transition of such data, which from the past products. So this has been at that time has been a groundbreaking case, because it is the first time the Chinese court has found or mediation have found database can be a kind of a subject matter for the copyright law, and also has been a subject matter for the unfair competition law. Since then, so you can see that the case was resulted in the settlements. The reason of that is still because at that time the Chinese courts has limited amount of knowledge or limited amount of experience in dealing with new type of data relevant unfair competition cases. So they are very hesitated to judge the case. So therefore the Plus or macro hill decided to settle the case, but with the condition that the infringer has admitted the infringement and agreed to pay the damages. So this case has been very important at that time. And since then, the Chinese law has been revised quite a few in different angles. In particular, in the 2019 anti-unfair competition law, there are two major changes. One is they added what we call the internet clause, internet-based infringement clause. The second would be the good faith principle. So the internet clause has provided a different four types of cyberspace-based infringement, cyberspace-based unfair competition, including the operator operated in the production and the business activities using different activities, such as inserting links or the forcing the redaction in the network products, and the misleading, deceiving the catching users, modifying without authorization, and also including any others actions in hinder or disrupt the normal operation of the network production or network operation in the services. So this kind of new provisions provided a very huge attention or provided huge remedies against the internet-based or cyberspace-based unfair competition, and worth a lot of tension on the business operators in Chinese market, including the foreign companies. And the second big change would be the good faith principles. Good faith principle has been in the law for many, many years, but still the unfair competition problem has been not been 100% on how would they be reacted or how would they be applied in the context of internet-based unfair competition or data-relevant unfair competition. So this new law, when they revised, has clearly identified as the unfair competition includes the first action by the operator in the production and the business activities that violates the provision from the law or disrupt the market in competition order and harm the legitimate interest of the operators or consumers. So this gave a huge advantages to the business operator in quoting this article to combat the data relevant infringement or unfair competition. So also when we found the cases, we found that quite an increasing number of cases has been judged and decided in China, including the Weibo case, including the Toutiao case or TikTok case, including the Hantao case against Baidu. So all of these cases has been quoting the Article 2 or the Internet Article 12 of the Unfair Competition Law in deciding, in finding the Unfair Competition Act that has been found as under the Unfair Competition Law of China. And what is more interesting would be in 2022, there's a new draft amendment of anti-unfair competition law has been released by the ICIC, now the SAMR, that has been newly introduced in its Article 18 that they have provided a new type of subject matter and unfair competition law that is called commercial data. So if you go through this article, the contents of this article, you will see that it has been a kind of similar to the provision on the trade secret protection under the Article 9 of current anti-unfair competition law. I think most of the audience today will be aware that the current law provides a protection for the trade secret as long as it has been secret or before it had not been undisclosed. Secondly, it has been taken a certain technical measure to protect it, and certain have industrial value or commercial value. And so the new provision on the commercial data has adopted a similar scheme of protection. It provides that it has to be collected by the operator, and secondly, it has been taken a certain technical measure to protect, and thirdly, it has been a consumption issue on this. So this has been, and the most important point would be it has been a useful measure on the commercial data to be identified as long as it has commercial value and it does have been taken that certain technical measure to protect the commercial data, and they can be possibly be protected as commercial data. So this has been a very new provision that's provided a new type of subject matter under unfair competition law. So they also gave a huge space in the future on the data, from the data perspective, on the data-based unfair competition cases can be judged, can be judged in China, where the data relevant infringement can be found as violating this new article, and it can be found as liable. So this is very new and very important. In particular, when you go through the data relevant company, such as Appin, you have huge data in China and across globe. You have huge value across globe, and then you can, if someone has been stolen your data, abusing them, and in any other ways, and the possibility of fall in the scope of this protection, this permission, and potentially they can be judged and can be prosecuted and under the law. This is the first part, and the second part, the rest part will be I will go through some other new types and for competition we handled for our clients. The first case we deal with will be on the can I change the position to go?
Sorry. How would you like to change it?
I can see for you.
You can, but then you will not be on the camera.
Okay.
Sorry.
So
I mean, you
from this case, this is a very new case handled for the famous US franchising company called Tupperware. As everybody knows, Tupperware is a world famous homeware manufacturer, and the case we handled was on behalf of Tupperware against its Chinese competitor from Li Xiangrong as individual. Li Xiangrong himself has used to be one of the partner or one of the franchisee of Tupperware before he left the Tupperware and joined another company. And the company, the new company has been joined, was actually a competitor of Tupperware. So from there, in the background of the case, first of all, we want to let you know that there's a regulation of administration of commercial franchising in China. In this law, in this regulation, that provides the franchise, we do have a provision on the franchisor and franchisee, where the franchisee, in terms of the franchisors, they provide their the business materials, the franchising materials such as business logo, the trademark, patents, and also the other technologies and so as other materials as commercially valuable and can be used in the franchise activities. And under this mechanism, there are a huge amount of foreign franchisors has been working in China. If you go through China, you learn a lot of such as retail shops, 7-Elevens, a lot of them are actually in terms of using this mechanism. Because mechanisms have huge business benefits that it can be easily develop the business as long as people are taking the principle or agree to abide by the laws or by the rules established by the brand owners, and they were able to join and able to follow the rules and do their business. And business can be expanded very swiftly in China. So under this mechanism, the Li Xiangrong is one of the people in Shanxi, Xi'an city, Shanxi province. He agreed to join Tupperware about 20 years ago. And since then, he has been established or entered the franchising agreement with Tupperware. So in the agreement, there is a certain very important provisions. One is that he has to be he has a right to use the business materials or business resources provided by the Tupperware. And secondly, is that he's not allowed to distribute any other branded products within the franchise store of the Tupperware. So this is very important because in this provision, they're not allowed to either to distribute within the store, and secondly, they're not allowed to do the business in competing with Tupperware in any other locations or in the business world. So this has been very important. And then in this case, Li Xiangrong, you go through the contract or the agreement franchise, you see all of the obligations that have been made under this agreement. So they're not allowed to use the Tupperware brand or Tupperware trademark, any products they have been distributing in the franchise stores, any other places, or not to do the business rather than abusing the Tupperwares in any location competing with Tupperware. So therefore, when we take the case, there was a question that whether we should pursue the legal liability against infringer on basis of a contract law, or we should actually pursue the and there's an unfair competition rule. So the difference here would be that under contract law, as I understand, first of all, anything liability you can pursue will be under the agreement. But secondly, in terms of the damages you can collect, will be only on the agreed amount of a breach of the contract. But if we go through the approach of unfair competition, it is the old amount of the damages that will be provided under the law, which is as much as 5 million RMB, is much higher than one of the under the contract law. In addition, in the contract law, under the contract laws mechanism, you will be able to only pursue the liability against the contracting party, which is the distributor, Xiaolong himself, but not for the manufacturer or for the people behind him, which is Y Super, is another big company. The Y Super, very interesting. I disclose a little bit more about Y Super. The Y Super was actually established by the former employee of Tupperware, and the Y Super, the people from established Y Super, actually most of them are used to be an employee of Y Super 10 years ago, and they left the company and established their own companies competing with Tupperware. So this happens in China. It's very big challenges to foreign companies. Now the people are leaving, they establish competing companies, and then they come back to you. So when the users established the company, what they did was, first of all, they started to sell their own products, bearing the trademark of Y Super, not the trademark of Tupperware. But they're distributing the products in the franchising stores of Tupperware. But because there's these customers mostly come to buy and come to see. So they distribute everything, these infringing products, they distribute Y Super products within the franchising store. And secondly, everything remained the same because first of all, there's a mix of products being sold. One is on one side, you will see the Y Super products in the store. On the other side, still they're being distributed the Tupperware stuffs. And technically, they're using everywhere in the stores. They're still remaining using the Y Super logos, Y Super company signboard, the trade names. Everything is being used over there. And also, they're using their slogans. Also do it DIY by yourself to be more healthier. So they're using this. And so this has been a huge violation against the interest of Tupperware. And then there will be we will see a lot of overlap for the Tupperware I just mentioned, because personally, the Y Super started by the person who has been the former employee of Tupperware. Therefore, they have a personal overlap over there. And secondly, the two companies are actually important. Geographically, they're very overlap. Certainly, business scope, of course, because competing, they have the same business scope. And lastly, because business model, they adopted the franchising business model in doing the business. So when it goes into stores, you see this. On the left-hand side, you see the Tupperware, the store signboard. In the middle, you will see there's a mix. On one, it's a hand shoulder to shoulder on the Tupperware stuff and the Y Super stuff are being sold in the same store. The third, the right-hand side photo will be they're using the Tupperware packaging to sell the Y Super stuff. So this is also being mixed. And the one that goes to WeChat advertisement, the distributing person of the Y Super, they're using their WeChat group, which is called the Tupperware group. So Tupperware group, they used to collect their franchisees from the WeChat. And the WeChat, they can collect a lot of people in the same group and they provide the materials to attract more people and distribute themselves and advertise themselves. But when they use the same group to advertise the brand of others, you will see how much impact it will have against Tupperware. So therefore, as all the factors we discussed about, we have been also reviewed the contract, because the contract per se has been a very important rule. There has a contract validity issue, and also we see there is a contract issue will be how they will bear the legal liability after termination of the contract. It means even if the people have left this contract, have terminated of ended the contract after the end of the contract. Still, they are not allowed to use a signboard or not allowed to use the logo of the trademark of Tupperware of Tupperware after they terminate the contract. So this has to be a legal provision and contract provision in the contract initially. So when we sue them, we see this as a huge important factors. Then the people will see whether we should do this in infringement cases. And so I go through quickly. And at the end of the day, when we sue them, we will go through the unfair competition law, as I just mentioned, the damages stuff, and also the aim or the objective to seize the infringement from both the franchisor, the Y-Super, and also the franchisee from Lixiang. So we have seen the case, won the case in 2022, and also the appeal case was won in 2023 and 2000. And then the retrial case also July 2023. So the final decision in the COM and then find infringement against two infringers, Y-Super and the Lixiang, and also the damages as much as 60,000 RMB. So it comes to the say if you infringement, you get protection, but if people have the authority scope, but when you out of the authority, you will possibly be found infringing unless there are company defensive manufacturers. In conclusion, we find this also there was a lot of dispute on whether in the same store you use as a trademark, others being sold in the way that's confusing, was infringing. There's also a lot of discussion because of time here. I'm not going to too details. And basically, if you based on the what do we call the initial confusion doctrines, you see that even the people cannot confuse at the end of the day when they come into the store and can differentiate different products, but still there's a competitive interest when they enter in the store because they see the logo, they see the trademark of Tupperware, and then they made the decision to enter the store. So there's a huge advantage and initial confusion on the one they find the infringement in this case. And the second case, it'd be more simpler. So, more simpler, the case will be come to the problem of the trade dress. You probably know there are limitations in China, and the people imitate the design of your products, and they resell and they sell them, and they manufacture and sell them. So the case come to a Japanese client. We represented Endo. So Endo has been a balancer. What's called balance balances as industrial tools and many being used to manufacture the automobile manufacturer. And the infringer, they copied, almost imitated the design of the infringer. Of course, the owner did not have design patent there. And then the infringer in using them, and also they have been using a lot of the pre-entity registered trademark. They have to tackle this first step, and then we go to see the infringing case. The infringing case we sue them under competition law on trade dress infringement. So the trade dress infringement has been a long history in China. Initially in the Ferrero case back to 2006, the first case in China against this chocolate design can be protected and law as a trade secret. And also the Chengguang case, the pen, the design of the pen. Technically, it can be protectable under the unfair competition laws. That has been the judgment of Secret People's Court. So in general, when you come to the packaging limitation kind of stuff, it can be protected not only under unfair competition, not only the letters design, not the letters or devices or its combination, but also for the shape and the configuration of that design. This is very important and very useful to tackle against the trade dress infringement. So in our case, we allege this two types of trade dress. We tackle them large scale or large end, high end or low end. And then in the end of the day, we have a favorable judgment in 2019 and the second instance in 2021. And they found all the infringing logos as copyright infringement. By the way, I didn't go to the detail, and also the designs as trade dress infringement. So all the details have been put there: patent, copyright, trade dress, trade name, training children, unfair competition, design patent. So all the protect, but the unfair competition is a huge potential sales. It's not required to do the registration first place. As Lisa has mentioned this earlier, that's a lot of IPs in China, they require you to do the registration first step before you enforce them. But for the unfair competition law, they're not requiring to do the first step of registration. So when you find imitation and you do not have a registered IP industrial property or IP interest or trademark patents probably rely on the unfair competition capital. So the last will be the principle of honest and mistrust principle. This will be very important when you tackle a new type of infringement, new type of unfair competition, because sometimes, as I just mentioned, the new type of infringement that emerges from time to time do not been categorized under the law, because unfair competition have 6 or 7 different types of law in the text. But when it comes to something that's out of this range, you got to rely on the Article 2 of the unfair competition law on the honest and fair competition principle. And also, you see that unfair competition center Article 3 also provides you a lot of context in how to explain this article. So you go through a lot of judicial guidelines issued by the presidential high court. You see a lot of different new things such as the gaming industry, such as in online business industry. There's a lot of new merging issues over there. So the one that judge the cases, they have to quote the Article 2 and the judicial interpretation in order to support their claims. So in general, I summarize the discussions about AUCL, anti-infringement law. They have a comprehensiveness and supplementals. So comprehensiveness is very broad range of applicability. And supplementation means that it supplements other protection for your IP, which has not been protected as a traditional IP rights, such as patents, such as copyright, such as trademark. And it has an innovativeness and forward-looking. In some cases, has never happened before, and it can be hardly be protected in other IP, industrial IP. And when you go to the anti-fair competition, and it has a principle because it has a lot of principles just mentioned. It also is rules against behavior rather than the property. So when it comes to behavior, it has to be very behavior-based infringement, behavior-based violation. So have been easy to be picked up, easy to be judged than a lot of property-based property-based laws. And the significance of anti-application law in business. So when you have exclusive rights, copyright, patents cannot provide a sufficient protection, you go through the application. Especially new subject matters, new internet-based infringement, cyberspace, database, then you go to them. And then also you got technical fields, other technical fields. So lastly, I feel a few minutes discuss the things on the emerging type of IP in China. So the reason I discuss this is pretty new. It's a brand new thing. I think this as part of this something that never encountered before, because as you know in China, because the Chinese entries WTO at the beginning of this century, so most of Chinese laws actually in compliance with international treaty and very similar to other foreign countries, Western countries, Europe, and the US. We will find you'll see a lot of similarity between the laws in China and the rest of the world. But for this new front line, it appears that Chinese government want to make something different, want to make something new, or they believe that they want to try to something new. So the principle here would be this 20 data mirrors, or data 20 mirrors. I'm sorry, it's a typo. Data 20 mirrors. So this code was the 数据20条 or data relevant 20 clauses. This provision are initiated or issued by the Central Committee of CPC and the State Council in the end of 2022. So the basic logic there would be they want to establish the mechanism or property system in China and promote the circulation, the trading of the data in China in order to improve or develop the Chinese economy as a whole. And then when they go through there, you will see that they have the code that they will create some new mechanism or efficient or protected data circulation and transportation mechanism or system in order to have to promote data economy. So this is what the initial aim. They want to create a new digital market to make what is called data to flourish in China and to promote its economy. Because data is so important, as everybody knows, it's so important in AI technology, in the AI relevant automobile, in the computer industry, IT industry. So it has a huge impact. It's very important in almost every single angle of the new economy. So they want to circulate this, they want to use new data in order the new production materials, as mentioned, and they want to utilize and promote them. So how they promote them will be a lot of different considerations. So up to now, we have seen after a lot of considerations and brainstorms in China, one of them will be what we call the Beijing Mirror. The Beijing Mirror is initiated by the Beijing municipal government, so it has been making some new new attempts in order to establish a new mechanism. The mechanism they were try to use will be intellectual property. So they want to pilot new areas, national data IP work into the exploring and implementation of new data IP registration system. So this has never been happened before, not in China, not in any other foreign jurisdictions. And under this new consideration, the CINIPA, the CINIPA, China's International Property Administration, they have also been very earnestly discussing on this. So one discussion made by the head of the CINIPA, they say, we want to make the main subject of the protection and to regard this as have undergone the processing according to the data. So when they go through the object, they want to find some new object for protection, new object of data to be protected and to be utilized through the registration of data processor and granted the certain rights. So it means that the CINIPA, they want to make up a new mechanism that will grant the data right, data relevant IP right to both, simply to be both the processors and the data holders, initial data holders. And also there's some new consideration under this Beijing IP office also been initiating their own mechanism. So they have provided some specific procedures for the people to register data as an IP with the Beijing IPO. And so different diverse approaches has been taken by different provincial IPOs or different provincial governments. What we have learned is that the Beijing mirror or the Beijing approach was taken also by Jiangsu province and Zhejiang province, and which is slightly different from Guangdong province, or in particular Shenzhen City. Shenzhen City said they do not want really to register this just as IP, but more broadly as property rights. So that is the approach that has been taken by the national NDRC, the National Development Reform Committee. That mechanism will regard the data not just not as IP, but as a broader sense of property rights. So under that mechanism, the Shenzhen government has to take the registration mechanism for data as registered as a property right rather than intellectual property rights. So, but although they're diverged, they're following the same principle. That is to make the data market more active and to make data go into the circulation and make the data to be as much as possibly to be used by the industry and by the commercial world. So you see that they started obtain and use it through legal regulations and the contract agreement. So there's a lot of discussion, such as people, in some provinces, some people say the most would be better be regular by contract, but not by property law. But in some provinces, such as Guangdong province, is more inclined to take it as a property and they register them as a property. But in Beijing and Zhejiang and Jiangsu, they more to take it as a intellectual property, and they want to be registered new type of intellectual property, and grant them the general registration certificate in order to make time finish in 5 minutes. So in general, so of course, there's some new issues or controversies over this, because the most biggest problem here would be any IPOs in discussion, they claim they declare that they do not do substantial examination like patents. They just do a formal registration. So this is very important because no people here would be able to examine this. You can imagine how complicated the data would be. The data would be collected from the public domain. The people, a lot of, including some personal data, maybe, including industry data, maybe, also including some very important data, maybe, and all the data being collected by the different industry players here. And then when they collect them, of course, there is some formal claim that I agree you to claim my name, agree you to claim my data, blah, blah, blah. But how would the scope of this has not been so clearly identified when they collect the data over there. But when they use them, they can use them in huge amount and in a huge scale. So they come to the question about how you verify the ownership of those data, and whether they belong to the individual who provide the data, or whether they are being owned by the processor who really make the data to be a part of the industry, or they should be owned by the commercializer who are really in the commercial world, they're distributed, transact those data and make them to be more active to be transactioned in the business world. All of this has not been fixed. So the answer would be the IPO that cannot verify them. So they just gave a formal data certificate that makes it to be a part of the business in the factor or in the part of the business circulation world. And then, but I want to let you know is that very interesting. Recently, there have been cases judged in China. Very recently in this year, earlier this year, the Beijing IP court and Beijing Internet Court is the first instance court, and Beijing IP court second instance court. The judge the first case in China regarding the certificate of IP certificate, registration certificate of data. So when they judge this case, the plaintiff provided the court with their registration certificates of data that is acquired from Beijing IPO, and the Beijing IP court and internet data, internet court and Beijing IP court, they adopted it, they accepted it, and they judge the case on the basis of this. They say when they judge the unfair competition case, they judge this on basis of the registration certificates obtained from the Beijing IPO. So this case as a milestone case. So that's been a very insightful. I think in the future is worth our watching, worth our attention. So how this story will be play out in the future. And for foreign companies, because the data resources or database companies, a lot of new issues may worth our attention in the future to when we develop our business, whether the data has on one hand not to be compliance, on the other hand, they can actively be used and actively commercialized. In particular, when you deal with your Chinese partners, and to make the things be easier to run. So lastly, give me 1 minute to discuss my firm. Except in 2000, now we have 4,500 professionals, and we're one of four largest law firm in China. We have different areas across almost every single province of China. In addition of which, we have offices in Bangkok, in Washington DC, Sydney, and in Paris. So we have overseas educated over 1,000, and ISO 300, master degree, 1000. We deal with, we're comprehensive firm, not just about IP, with different disputes, commercial disputes, foreign investment, and others. So being very acknowledged by LP, Chamber of Commerce, and others. So different. We have a huge number of trademark patent attorneys. So a lot of that provided different category of service, trademark, patent, copyrights. And also data. Recently, we helped the people to do the transfer, cross-border data transfer compliance, and help a lot of European companies over there. And the head of our international ties was president of the China Bar Association. So I myself, a graduate diploma in the US and previous work with Baker McKenzie, and also can also obtain my allowance in both Duke and China from the First University. We're recognized by chambers, by managing IP and other WTR and some international license. Published a lot of articles, including European Union, European Commission, and others. So we have been working with DKIPO or DKPTO, the meeting in China, presentation, training in Denmark, listening Copenhagen and another city of Denmark. We work with Italian chamber for the data protect, data compliance workshop, and the UK embassy for their secondary liability on online infringement. And work with INTA. I'm a member of INTA China copyright China trademark office committee. We're working with trademark office and a lot of legislation stuff. With the Berkeley of the US, representing the trademark law revision early last year. Representing chambers, HIP, WTR. So this is my son. So I'm happy. So thank you very much.
Great, thank you very much, Charles. And I think that we can go now to perhaps a presentation that looks more on the practical side of things. If you're an SME, if you're a European company, and you want to get a license for your software in China to operate and sell, like how do you do that? And that's where you and AppinChina come in, Phillip. So the floor is yours. And okay.
Yeah, thank you so much for the invitation. Thanks for having me. It's a pleasure to be here. And yeah, we just heard from Lisa and Charles about IP protection in China. Very interesting. And I think now we only have one question left, which is how to actually publish and operate your software in the Chinese market. So my name is Phillip. I'm the sales manager, business development manager at AppinChina. And we are China's leading publisher and operator of international software. And today I want to give you some practical insights how you can publish your software in the Chinese market. So I think sometimes people get a little bit confused what it means to actually publish and operate software in the Chinese market. So I just want to clarify what we mean by publishing and operating software in China. So yeah, so when we go to the next slide, you can see publishing model. So this is our AppinChina publishing model. So if you have software, you can see AppinChina is there. Then we license your IP and we license your software. So you don't need to have your own company in China. We license it from you, and then we publish it in China by providing you with a cloud account under our Chinese entity. We give you full access, and then you can set up your cloud infrastructure by yourself. Of course, we provide technical support together with the cloud service provider. So we work very closely with AWS China, with Azure China, Alibaba, and Tencent. Now, our collaboration agreement makes it very clear that all IP and the ownership of the software belongs to you. Okay, we only license it. So for example, a trademark will always be held by your overseas entity. Yeah, it will never be held by us. Yeah. Now, if your software generates revenue in the Chinese market, then we, as the publisher, we have to collect that revenue for you. We pay all the service fees, taxes, we take a revenue share, and then transfer the remaining amount to your overseas entity. Now, if you have, let's say, international clients that pay for your software solution in China outside of China to your overseas entity, then of course the revenue does not need to go through us. Yeah. If you also have mobile apps, then we can also help you to distribute the mobile apps across the different Android app stores, right? So Google Play Store is blocked in China. Instead, you have a lot of different Android app stores. Huawei is the biggest one. And then you have Oppo, Vivo, Xiaomi, Samsung, 360. So many different Android app stores. And we can handle that distribution for you as well, and even publish your iOS app in China if you want us to do this. But for a typical, let's say, B2B SaaS solution where you don't have apps, then yeah, we just provide you with a cloud account, and then you can set up your cloud infrastructure by yourself. So why is our service needed? So the key reason why our service is needed is that many of the key licenses that are required to publish and operate commercial software in the Chinese market can only be obtained by a majority-owned Chinese company. Now, the most common example is the B25 commercial ICP license, which you need for any commercial software in the Chinese market. Now, recently, the Chinese government actually announced that they want to make it easier for WOFIs, for wholly foreign-owned enterprises, to obtain those licenses. Okay, so maybe in the future, you can also obtain those licenses with a foreign invested company. Right now, there's still no clear announcement, policies, requirements from the government. So that's why we are still right now assuming that it's not possible or difficult, but this might change in the future. So we are 100% Chinese-owned company. So we have all of those licenses you need to publish software in the Chinese market. Now, there are other solutions as well. So, for example, you can set up a joint venture or a VRE structure where your WOFI controls a 100% Chinese-owned company for a series of controlling agreements. And then, of course, you can also obtain those licenses, but of course, those solutions also come with their own risks. So you can see here, we do this for a lot of clients. We publish and operate over 300 of the world's most popular apps and SaaS platforms in the Chinese market. We work with many large companies across many different industries, but we also work with smaller companies, SMEs, startups, so a very diverse client portfolio. Now, of course, not all of those companies use our company as the publishing entity. Okay, some of them, they have their own company in China, and then we only help them to publish their software under their own company. Okay, so we can still, for example, manage the entire app distribution process under their own company. So it's really your choice. Yeah, we can work together in both scenarios, whether you have your own company or whether not. Right? So it's really most important is to make a decision. What is better for you, right? Do you want to set up your own company or not? And how do we decide this? Well, that mainly depends on compliance. Okay, so you can see here, we offer a wide range of services to make sure that your software solution is successful in the Chinese market. But the core service is really compliance. So let me explain this a little bit more. We separate compliance into 3 different categories to make sure it's published and operated in full compliance with Chinese law. The first category is entity compliance, which refers to the licenses that must be held by the legal entity that will publish the software. And this is what I was referring to at the beginning, right? Some of those licenses are difficult to obtain with a foreign invested company. So those are per company. We already have this license. The second category is software compliance, and this refers to the filings and certificates that must be obtained, specifically for the software that will be published. So specifically for your SaaS solution, or for your website, or for your WeChat mini program, or for your app. There are different examples, and I will explain them more in a second. And then, of course, we have operational compliance, which refers to the laws and regulations that must be followed. For example, data export. That is very important, a key focus of the Chinese government. You follow the data export regulations. You need legal documents. You need a privacy policy in terms of service. Maybe content review is needed, revenue collection. So all those fall under operational compliance, and we can also help you with that. So let's look at those different categories a little bit more detail. So the first one is entity compliance, right? So here, as I explained before, there is the B25 commercial ICP license, which you need for any commercial software in the Chinese market. Let's say you have a B2C app, and you have subscriptions that clearly falls under the definition of commercial software. There's also another license called the B21 Electronic Data Interchange EDI license, which you normally need for e-commerce platforms. So if you have an e-commerce platform, then this license is required. And then another one is the broadcast and television license, which you need if your software solution contains a lot of videos, like pre-recorded videos, then this license is needed. Now, if let's say you have live streaming, then you need another license, okay? But the live streaming license is very difficult to obtain. We currently don't have this license, right? And then we would need to find other solutions. But otherwise, all of those licenses we already have. So we don't need to obtain them to publish your software solution in the Chinese market. All right, let's look at the second category, which is software compliance. So we need to obtain those filings and certificates specifically for your software. The first one is the ICP filing. And this is the basic filing, the basic requirement for hosting any information in China. So for example, if you want to host a website in China, if you want to make sure it will not get blocked, then you need to get this ICP filing. And it's pretty straightforward. You just need a China-specific domain name and then host your website under this domain name. Then you can get the ICP filing. You'll include it on your website, and then it will not get blocked. Now it gets a little bit more tricky. You can see the next one is ICP filing for mobile applications. And this is relatively new. It was implemented by the Chinese government specifically for mobile applications. So now each mobile application also needs an ICP filing. And not to confuse those two with each other, we normally call this the mobile app filing. Now, the intention of the law of the mobile app filing is that the entire backend infrastructure is hosted in China. Why? Because when we apply for the mobile app filing, we have to submit and declare all the domain names and IP addresses by your backend servers. And only Chinese domain names and IP addresses are accepted. Otherwise, you can't even submit the application. Okay. Now, if you use third-party services like APIs or SDKs, you can still use them as long as they work and as long as they are compliant. Okay. Because we don't have to declare them during the application process. Okay. Now we understand. It sounds a little bit scary. And for some clients, this is not even possible to move the entire backend infrastructure to China. Yeah. One possible workaround solution is to use a proxy server that then connects the front end, let's say, of your mobile app with your backend infrastructure outside of China, and then it still fulfills the legal requirement of declaring all your endpoints in China. Yeah. But this only works if there are no other compliance requirements. Okay, so for example, if you collect and store personal information, those always need to be stored in China first before you can export those, right? And in this case, you at least need a database in China. You can't just, export this freely out of China. You need to store it first, and then it depends, right, how you can export it. Yeah. The next one is the software copyright certificate, which Lisa mentioned before. And this, as we already heard, it protects the ownership of your code in the Chinese market. And this is a requirement by the different Android app stores. So if you have an Android app and you want to make it available across the different Android app stores, then you definitely need the software copyright certificate. If you just have a B2B SaaS solution, you don't need to get this. It's not a must-have publishing requirement, but for apps, yes. Or if you want to run, for example, Apple search ads in China, then Apple normally also requires the software copyright certificate. But don't worry, right? You only you can submit non-critical source code. So you don't have to worry that then your source code gets stolen or copied. Yeah. Also, it actually sometimes happens with popular Western B2C apps that there are some copycats on the different Android app stores. But don't worry, that's actually a good sign, because it means it's popular in China and there's a market for you, right? In this case, we just get the software copyright certificate for you, and then we remove all the copycats from the different Android app stores and then publish your app there. Yeah. Okay. Another software compliance requirement is the MLPS filing. Now, the MLPS filing is a filing for software that it is required for software that could cause harm to China and to Chinese society. Okay, there are different levels. And the levels are determined by the level of harm the software could cause to China, basically. So this is especially needed if your software solution collects, let's say, sensitive personal information or important data, and a large quantity of data. Okay, and then you need to get this MLPS filing. It involves an officially licensed agency that determines the level. So this is not done by us. This determines the level, and then also tests your network to make sure it's sufficiently secure. And if you pass that test, then you will get the MLPS filing. But of course, this is not it's a time-consuming process. It can take anywhere from 3 to 8 months. It's also not cheap. So yeah, we always try to see, can we avoid the MLPS filing at the beginning? Okay. And if you, let's say, need the MLPS filing, then a proxy server will not work anymore. Okay. Because the MLPS filing requires that it's a self-contained system. So you need to move larger parts of your backend infrastructure, if not everything, to China. Another software compliance requirement is the ISBN number, which is needed for games. But I can tell you, very difficult to obtain. Yeah, there are only a handful of international game developers that receive that gaming license every year, and sometimes it even stops completely, and there are no gaming license issued. So this is challenging. And then the last one, a trademark, which you also heard today already. So this is very important. We will never hold your trademark, but it is not a must-have publishing requirement. Okay, you can publish your software solution without a trademark, but of course we strongly recommend you that you get a trademark. And then the last category is operational compliance. So this refers to the laws and regulations that must be followed. So as I explained before, data export, very important. So we look at what kind of data you are collecting, the quantity of the data, and then it depends on different thresholds, government thresholds, how you can export this data. But most important, it always needs to be personal information, PII, always need to be stored in China first. And then we take it from there. Of course, if you don't need to export any personal information, that's always the easiest solution. Then it just stays within China. Important to note, just by viewing it from outside of China is also considered data export.
Sorry, maybe just to interrupt then, if you're an SME that doesn't deal with a lot of data, how does this data export framework affect you?
So if you want to export data,
yeah,
how you can do it as an SME or?
As an SME, how would that data export framework affect you? Because I mean, unlike big companies, SMEs maybe deal with smaller amounts of data.
Yes. That's a very good question, right? So then we need to look at the different government thresholds. So right now it says if you are below 100,000 personal information per year, then you can just freely export the personal information. You don't need to do anything. And that was just implemented a couple of months ago to make it easier because everyone really struggled with exporting data. But it still needs to be stored in China first. Okay, but then you can just export it without doing anything. Yeah. If you are between 100,000 and 1 million personal information, then you need to sign a data transfer agreement. Yeah. And you need to conduct a data assessment. And then you need to file this with the Cyber Administration of China, with the local authorities. But you only have to file it. You don't need to pass like an assessment or something. You file it, and then you're good to go. You can export this data. Now, if you're over 1 million, right? Then you need to pass a security assessment with the Cyber Administration of China. And then this is much more difficult and a much more lengthy process. And I think even until now, only a few companies have actually obtained the permission to export this large amount of data. And then, of course, for, let's say, sensitive personal information, you have much lower thresholds than just normal personal information. So we look at this and then, of course, tell you exactly how you can do this in the best way. Does this answer your question? Okay, that's good. Next, content review and social functions. Also very important topics. They became very important, especially since COVID. So if your software solution has any social functions or user-generated content, you need to have those in place. Content review, which we normally do with an API. So you integrate with an API from one of the cloud service provider, let's say Baidu or Tencent, and then it automatically filters the content, and blocks content to make sure that no illegal, sensitive, non-compliant content is generated through users through your software solution. In addition to this, you also need to have an identifiable login solution, okay? So that if something goes wrong, if something happens, then the government can find you, can find the user, identify the user. And there are 3 main things that can be achieved. You collect and store the phone number, identity, like ID number, or social security number. And we always recommend to go with mobile phone number, because of course this is the easiest, this is the least sensitive data, and that's also, it's very common for China to use phone number to sign up. That's actually the reason why you most of the time need to use a phone number to sign up, because it is linked to your identity in China. So that fulfills the criteria of having an identifiable login solution. And I know this is sometimes a little bit difficult to understand, I think, for Western companies, or they ask, okay, why do we really need to do this? But it's important to keep in mind that it protects both you and us, right? Because if something happens, then the government will remove or block your software solution, and then a lot of trouble. And then bringing it back is difficult. So we want to make sure it's really fully compliant and safe. Of course, you need legal documents. You need a privacy policy in terms of service. Customer support, there are no clear requirements on customer support at the moment. So if you feel confident that you can provide good customer support by yourself, then you can do that. That's completely fine with us. But if you need help, we also have a full customer support service. So we can handle that for you. And then the last part is revenue collection, which I already mentioned at the beginning. If your software generates revenue in China, within China, also through your software solution, then we need to collect it. Yeah, then it will go through us. If you have international clients that pay you outside of China, then the revenue does not need to go for us. And you can see here, this is our compliance report. So what we offer is a free compliance assessment for all of our clients to make this decision, right? And to let you know what is exactly required. So we do this with our in-house legal counsel. We need to get a demo of your software solution, right? We just schedule a call, you share the screen, show us all the functions. We have some legal and compliance questions for you. We need to look at your system architecture diagram, your deployment plan. And then based on this information, we prepare and provide you with this very detailed compliance report in English with all the relevant laws and regulations. And then based on this, you can make a decision, right? Can I use my own company in China to publish and operate my software solution? Should I open my own company in China? Or is it maybe better to use AppinChina's company? Yeah, because some of the licenses I can't obtain or are difficult to obtain. And then the final decision is yours. Yeah.
I have to ask you to wrap up. Sorry, Philip.
Yeah, sure.
We have quite a number of questions from our participants. So if you can.
Yeah, sure. I'm almost done anyway. So just quickly, this is a typical roadmap. As I just mentioned, it always starts with a compliance assessment, which is completely for free. Once you've made a decision, we sign our agreement. We do the cloud account setup for you. We give you full access. You set up the servers, your cloud infrastructure. We provide you with all the certificates and filings, and then also can help you to test your solution and then launch your software solution in the Chinese market. Of course, this is just a sample roadmap. It can take much longer, depending on the complexity of your software solution and also how long it will take you to review, our agreement and provide you with all the information. So yeah, just to quickly go through the last few slides. As I said, if you have an app, no problem. We can distribute your app in China under our company or under your own company. Localization is very important, and don't underestimate this, especially if you have B2C software. Okay, make sure it is really localized for the Chinese market. A lot of Western brands underestimate the competition here. Okay, and of course, we can also help you with this, let you know what you have to change. We can test your app and then give you detailed advice on how you improve your localization. We can help you with go-to-market strategy, also user acquisition, so running ads on the Apple App Store or on other social media channels, for example, Douyin, which is the Chinese TikTok or Baidu. And last, monetization. We have our own payment solution. So this is very important for B2C customers, for B2C apps or websites. So you can directly integrate with our API, and then Chinese users can use WeChat or Alipay to pay for your software product. So WeChat and Alipay are the most common methods to pay basically for everything in China, and then it's very easy for you to generate revenue here. Yeah, I hope this was helpful to give you some practical steps how you can publish your software in the Chinese market. And if you have any questions or if you want our help, then just send me an email, philip@appinchina.co, and then we can schedule an introduction call. Right. That's it. Thank you.
Perfect. Thank you. So again, as I mentioned, we have several questions from our audience. I'll ask our experts to be brief in their answers so that we do not run too much, beyond our set time. And I believe Lisa is also trying to prepare some written answers to some of the questions, but let's just get started. First question, is it illegal in China to decompile programs or run binaries, executables, or on emulators?
It's not a very simple answer. I would still recommend this person to talk with the lawyers like Charles to explain the situation more in details to make the decision if it's an infringement or not. There are many considerations, many factors need to be considered, like the infringement itself and the IP, etc. So it's not a yes or no, that kind of simple question.
Charles, any?
May I take the question again? Can you take this again?
It's the first question. But while you, Charles, look at the first question, maybe we can go towards the second question. Yes. And that is, how can we ensure IP is fully protected in China in the case the protection has been applied in China?
For the trademark and patent, if it's only application, it does not provide any protection. You have to wait till the registration. However, in this phase, if you already encounter any like bad faith registration or infringement, this is the perfect time for you to collect those evidence to prepare for the enforcement, especially when your IP is registered.
Next question, what is the level of protection for a patent certificate for invention in China? What is the level of protection?
It's a multiple person, I can supplement. Give first question.
If you already have the patent certificate, invention patent certificate, that means the rights already granted and protected. And these certificates allow you to go to the court or use it as a strong argument when you send the cease and desist letter. In summary, it's protect you the strongest protection compared with the other, for example, when your IP is still in application, this kind of stage. This is for the invention patent, I believe. But if it's for the other patent like industrial design or utility models, you need to apply for other certificates, other reports like patent evaluation reports. But for invention patent, you do not need to have that because the whole patent registration procedure already provides the opinion from the examiner that your patent should be enforceable in China.
Charles?
First of all, I come first question. The complete foundation is something. First of all, it's not illegal in China in general. So when the people go to decompile, you got to be, first of all, to go through whether, from the copyright law perspective, decompile per se is not illegal. However, decompilation has been obviously relevant to patent, for example. If you go patent, you sometimes go to how the patent has been written in their claims. A lot of patent claims has been prohibited or intent prohibits decompilation in a lot of cases. So that was a consideration. The second would be the trade secret. The trade secret in general does not prohibit, again, does not prohibit the decompilation or decoding. But when you go through the trade secret stuff, you have to pay attention. So whether how does the decompilation has been made? So sometimes the decompilation were made actually on basis of a lot of information that's been in the secret situation, or some of the information obtained from the public, but certain part of them are actually confidential information. So all of this has been relevant to the questions that's been addressed. So I agree with Lisa that we would love to see the details of the question in order to give a more concise or precise answers to them. The second about patent, I think Lisa has been answering most of them in general. When the patent has been granted by Senior Partner in China, and they're of course been protectable under the patent law of China. And so the patent is one of the most important in technology protection, particular when you go through them, because patents, if there's an invention patent, they have been go through the substantial examination, and for design and utility model, sometimes they not go to the substantial examination in general. And but in terms of the ratio, of the invalidation in China in general is even the invention patents has a certain amount or certain percentage of successful invalidation in China. So that's not if you have even you have the invention patent being registered in China, you cannot say that 100% is being secured as valid. Because when you go to a huge patent infringement case, and that almost in every single case you will face invalidation proceeding.
And maybe also to follow up on patents, in the case of illegal use of technology protected by patent by a Chinese company, do we stand a chance if we take them to court?
Of course, yeah, that's we can have patent infringement cases. So this I may want to say something. Almost in most occasions, the people will need to go to the court. So the local IPO will do some administrative cases, but the number of them is very limited, and the geographic area is not very limited. So in most occasions, the people need to go to the court because of the patent infringement.
Okay. Maybe one question then to you, Philip, and then the last question to Lisa and Charles. So the question to Philip is, if your company helps publish software for SMEs or clients using your licenses, will you mark your company's name or the client's name for the software?
What do you mean by mark a name? I'm not 100% sure what that means.
Maybe the person that asked the question can elaborate. I don't know if you can unmute yourself, Ying. If you can't, feel free to elaborate then. Oh yeah, okay, good. I think you're unmuted.
Yeah, hi, Philip. Mark means yeah, maybe commercializing that because you are facilitating this, you are helping this, right? Can you hear me?
Yeah. Yes.
Can you repeat?
So
Please.
Marking the name means commercialization. So who will be shown as the owner of this software? Is it your company or your client?
Right. Okay, I understand. Yeah, so as I said, right, so the trademark will be held by you. Now, the software copyright, so if we are the publisher of your software solution, then the software copyright certificate, for example, must be held. If it's an app, it must be held by us, okay? Because that is a requirement by most of the Android app stores. If it's just a B2B SaaS solution, then the software, we can also get the software copyright certificate under your own company. Even with the Android apps, we can still get it under your under your overseas company, and then you can provide us with an authorization letter, and hopefully the Android app stores will accept this. The domain name, for example, which we will use to get the ICP filing, that definitely must be held by us. Okay, so the ownership of the domain name also must be held by us. Of course, the cloud account is also under our company. So the cloud infrastructure, your cloud resources will be under our company. But that's basically it, right? So again, our collaboration agreement makes it clear that the real ownership belongs to your company. Now, when you have a mobile app and when you go to the different Android app stores, then you will see our company as the distributor, right? Not your own company. So yeah, I don't know. It's a bit tricky to answer this question. So it really depends on the different situation, but how it is perceived from users, right? It might be our software, right? Let's say for apps. But of course, the brand and everything that is related to your company and that is owned by you and everything. Yeah.
Yep. Okay, last question then that we have received so far. In case of a collaboration between European and Chinese companies, how can we ensure that technical expertise that is provided by a European company is not unfairly used by the Chinese company?
I would say this question is not an IP issue now. It's more about the agreement you made and also the labor contract you signed between this technical expertise of European company or maybe the collaboration agreement with the Chinese company. And contract's one thing and how to implement it's another thing. Like this European company should have the opportunity or have the right to visit this Chinese company, especially if this European person works in China, have the right to visit the plants or the on-site work office without alerting, without noticing the Chinese company. That's a good way to avoid all these illegal things happen outside of the contract.
All right.
I'll add a few, one point that I say first of all, we want to differentiate the technologies that we want to share with your Chinese competitor, with Chinese partners. It means that in terms of technology, the companies may divide it into different kind of, for example, top secret stuff, then we want to keep it as a trade secret or technology secret. So we're not going to share. But secondly, for something, when you need to share, you need to share the certain portion of it, but not necessarily 100% of them. So the second way, as Lisa just mentioned, make the documentarized most important things, and then the documentation can be in bound with a different type of penalties against the breach of the contract, of course. The third would be make the, of course, as Lisa just mentioned, most important things, if they have to be shared, have to be used, and they have been a lot of values, then try to popularize them. Register them as either a patent or copyright. So that's to be very important when you really face a dispute in the end of the business, or you break up with the Chinese partners due to any reasons.
All right. So I think that's all in terms of the questions that we have, and that's also all in terms of the time that we have for today. But if our speakers allow, we will be sharing the presentations and their contact so that you can reach out if you have any additional inquiries to any of them. Thank you all so much for joining today's meeting on and offline. And yeah, we will be back with more working group meetings and more information sharing sessions. So stay tuned to both the EU SME Centre, the IP SME Helpdesk, and the European Chambers communication channels.